Hello, my name is Heidi Miller. I'm the county attorney, and we are offering this training via video this year so that we can try and reach as many of our boards and commission members as possible. I just wanted to thank you for the work that you do for the county. We would not be able to do all of the business of the county without your help, and we really appreciate the time and effort that you put into being a board or commission member. And hopefully this training will provide you some basic information that will be helpful to your role on your boards or commissions. Thanks.
I'm going to talk a little bit today about the format of the meetings for our county's boards and commissions. Most of you will have bylaws. They're not necessary, but if you do have them, please go ahead and familiarize yourself with them. They generally cover the rules for the boards and commissions, like whether you might have alternate members, how chairs and secretaries and vice chairs are elected, the duties of the chair, and they might also have some procedures, which could be important to know. The chair of your board or commission is the one who conducts the meetings and also helps to keep the meetings moving. They are elected by a majority vote of the quorum of your particular group. They also often have a vice chair, and they should be elected the same way as the chair, along with a secretary for the group. If the chair is unable to serve, then the vice chair will conduct the meeting, and then also if the chair is unable to serve with the vice chair, the secretary can conduct the meeting. For the order of your meetings, first and foremost, follow your agenda. The chair will call the meeting to order. Someone will do a member roll call. If you have a secretary appointed, the secretary can do that. If you have minutes to be approved, make sure those get approved at some point. Some boards do it at the beginning as the first order of business. Some save it till the end. And then you go ahead and conduct your business, whatever you have on the agenda for that day. We try to avoid procedures as formal as Robert's Rules of Procedure, but we do utilize basic parliamentary procedure. For example, most importantly, probably for your groups, motions. If there is a group discussion prior to or about a motion, the chair is the one who keeps conversation moving, and your goal is to get to a motion. When you have discussion, the chair may call on members for comments or questions, and any member may make a motion, including the chair, unless for some reason your bylaws say otherwise, and a motion must have a second. After a motion and a second, the secretary takes the vote of each individual member, and if by any chance you have an even number of members that day and the vote is split, that motion fails and you need to keep moving and see if you can get a motion passed.
Hello, I want to give you a couple of tips about this public hearing room in case your board or commission meets in this room. Many of our boards do, and so we thought it would be helpful for you to know a few things about the features in this room that will help you serve the public best and also make sure that you have a smooth public hearing. First of all, as you can tell, the entrances of the room have stairs coming down to the place where the podium is for the public. So if there's anyone that is attending a public hearing that needs an ADA accessible entrance, if you go out on the main hallway and on the east side of the public hearing room, there's an ADA accessible lift that can provide public access to this level of the room. And your staff contact for each of your board or commission can help any member of the public, but it's helpful if all members of the board are aware of these features. Secondly, there are hearing assistance devices inside of this podium in the cabinet here that can be made available to any attendees or any persons wishing to speak and observe the business of your board or commission, and they can be utilized in order to amplify the volume of the hearing room. And again, the staff members can assist with that, but we do want you to be aware of that feature. Your staff contact can also help your board utilize the timer in the public hearing room. It's common practice for many boards and commissions to establish a limit on public comments, and a common limit is 3 minutes per speaker. It's helpful to do that up front before the hearing begins, and then these lights here will indicate with the green, yellow, and red when the time limit has been reached. An audio indication can also be implemented. Finally, we want to advise all members of boards and commissions that meet in this room that when the hearing concludes, that you exit through the back door and through the employee parking lot. We find that that will help minimize any issues that could arise in the lobby or the parking lot, and so make sure that you exit that way at the end of your hearing.
My name is Doug Edelstein. I'm from the County Attorney's Office, here to talk to you today about open meetings law. In Colorado, the open meetings law applies to any governmental entity that's conducting its business through a meeting. You should assume that the law applies to your board. Under the law, a meeting is generally defined as any gathering of 3 or a quorum of your board, whichever is fewer, for the purpose of conducting or discussing its business. Please note that when we say gathering, we're not talking about a proximity rule. Discussions that occur in phone conferences or email exchanges or on social media sites can very well be meetings for purposes of the open meetings law. The law requires that at least 24 hours public notice be given so that the public can attend meetings if they so desire. And the law also requires that an official record of actions taken at the meeting be kept. This is usually done in the form of an audio recording. Please note that those informal or accidental or impromptu type meetings that can take place on something like a social media site might not meet these requirements and should thus be avoided. One thing you should also avoid is ex parte contact. Ex parte contact is generally when someone tries to have a one-on-one discussion with you outside of the general meeting format. You should avoid these. In case you cannot avoid them for some reason, your duty is to disclose the nature of that ex parte contact at the next meeting where your board discusses the matter. You then have a decision to make. If you can represent to the board that your decision will be based solely on information presented at the meeting, you can continue in the proceedings. However, if the nature of the ex parte contact is such that your decision will be based in sole or in part on the ex parte contact, you should really recuse yourself from the matter. You should similarly avoid doing site visits on your own or conducting your own research. To the extent practicable, please contact the staff person associated with your board to have these things done in compliance with the open meetings law. As you can see, the best way to avoid problems with the open meetings law is simply to keep your discussions on board business to the regularly scheduled board meetings. If you have any questions, please contact the attorney who works with your board. Thank you.
So I'm going to talk to you a little bit about ethics and some other legal matters that we just want to make sure all of our boards and commission members are aware of. The first is that we have a code of ethics for the county. The state also has statutes and regulations regarding ethics, but it's most important that you understand the county's code because that applies to you specifically. It applies to employees and officials, and we've written our code to include you as volunteer boards and commission members as part of the officials category. Generally, the key to these ethics issues is the appearance of impropriety, and to really make sure that your actions that are in any way dealing with county business cannot be perceived as being unfair or having some bias. As Doug discussed with regard to communications outside of the meeting, anything that looks like you may be gathering information or have a sway or a bent before a decision is made can be problematic. When in doubt about whether something is allowed or not allowed with regard to the code of ethics, don't hesitate to contact the county attorney that's associated with your board or commission. For some of you, the county attorney's office role is obvious. We're sitting at every one of your meetings. For others, we may not be as involved, and you should just ask your staff person if you have any legal issues, and they'll make sure that the right attorney gets involved. So I want to read a couple specific provisions from our code of ethics that are critical and that do apply to you. No official or employee should have any direct or indirect interest, financial or otherwise, engage in any business or transaction or professional activity, or incur any obligation of any nature which is in conflict with the proper discharge of his or her duties in the public interest. So again, this provision is really getting at you having some type of financial interest in what is happening before you as a board or commission member, or certainly the receipt of any gifts or bribes or anything of that sort. And then also, an employee and official should endeavor to pursue a course of conduct which will not raise suspicion among the members of the public that he or she is likely to be engaged in acts that are in violation of the public trust. And again, I think this goes to what I talked about earlier with the appearance of impropriety. So state law talks about the requirement that you recuse yourself from any matter before a board or commission in which you have a financial interest. There may also be times other than that your involvement in a particular situation or your relationship with one of the parties or witnesses makes it impossible for you to be a fair judge on that particular issue. Again, contact your county attorney, talk to them about those situations where you think you might have a conflict of interest. The county's code of ethics includes a specific ban on receipt of gifts. There's also state law, constitutional provision that has this ban, but the county's code of ethics applies that ban to you as members of our boards or commissions. That ban essentially says that you cannot receive gifts of any value, you cannot receive gifts from any person if the value exceeds a set amount. Currently, that's $59. It changes occasionally. And then also in our code of ethics, we say that you cannot receive a gift of any value from vendors or others doing business with the county. And particularly for boards and commissions, that includes any applicant or someone with business before your board or commission. So please ensure that you're very careful about taking gifts from anyone. And again, if you have questions about what's allowed, don't hesitate to reach out to the county attorney's office. Our code of ethics also talks about the importance of confidentiality and not using information that you gain in your role with the county for any other purpose. It's very important that if you learn information that you are told is confidential or is not for public dissemination, that you keep it confidential. Some of your boards and commissions may occasionally have executive sessions. Executive sessions are specifically designed under the law to be confidential meetings that are not part of the public record, and anything that's discussed in those executive sessions needs to be kept confidential within that group. So please be careful about that as well. We also just want to let you know that the Colorado Open Records Act applies to all official actions of the county, with a few exceptions. In particular for you, your personal email, your personal phone should not be subject to open records. But if you are sending emails or text messages or leaving voice messages for county employees, it's likely that those records then become public. So just be aware that all of your communications with staff or other board members regarding the board or commission could be a public record. We also want to discourage any statements to the media, whether it's social media or traditional media, where you are speaking on behalf of the county or on behalf of your board or commission. It's very important as citizen board and commission members that you only speak as individuals. If there is going to be a statement made by a board or commission or by the county, that needs to be done through staff and hopefully through our public information officer. But please be careful about those statements.
I'm Michelle Tyler-Michael, Assistant County Attorney. I'm here to talk to you this morning about some employment-related policies that might impact your experience here at Adams County. First up, discrimination and harassment. Now, board and commission members are volunteers, not employees of the county. However, you will interact with employees and citizens during your time here at Adams County, so we want to make sure that you follow our policies against discrimination and harassment. First up is equal employment opportunity. When making decisions, and including the decisions that you're making, you should consider merit-based characteristics and don't make decisions based on legally protected characteristics, including race, color, national origin, ancestry, religion, creed, sex, sexual orientation, age, disability, genetic information, and veteran status. The county and federal law also prohibits harassment based on any characteristic protected by law, and that's the same characteristics that I just listed. Harassing conduct can come in many forms, including slurs, negative stereotyping, jokes, hostile actions, or physical touch. The law and Adams County policy also prohibit retaliation. So if employees of Adams County make a complaint, whether that's a complaint against another employee or a complaint against a board or commission member, they will be protected from retaliation by the county. If you witness or experience discrimination, harassment, or retaliation, you should report it right away. Please report to your assistant county attorney or directly to Human Resources. If you are pregnant or have a disability and need to have an accommodation that would allow you to perform your volunteer duties or to continue to perform them, please contact, again, HR or your assistant county attorney. Same goes if you need an accommodation for sincerely held religious belief. Adams County prohibits violence and threats of violence. There is no right to privacy in county desks or other county property. If you witness violence or experience any violent threats, again, if it's an emergency, contact emergency personnel or contact your assistant county attorney or human resources.
Hello, my name is Christy Fitch, an Assistant County Attorney with the Adams County Attorney's Office. Thank you for taking the time today to listen to our presentation. On this page, you will find important contacts of county employees who you may interact with from time to time. This slide also gives you the Human Resources main line and the contact in case there's any kind of weather emergency that may affect your Board of Commission meeting. Again, if you have any questions regarding this presentation or your board or commission, contact your staff member for your board or commission. You can also contact the county attorney's office if you have any questions regarding this presentation. Thank you again for your time and your service to Adams County.